In most markets, businesses manage risk through contracts. Businesses operating in India need to think beyond the contract. And in a justice system plagued by delays, many times even beyond the law, contracts matter in India, but enforcement is slow. Operational risks in India fall into several categories. The legal framework is there, the courts are there, but the businesses that succeed long term rarely need the latter. Hello, and welcome back to the Veyrah Law series. In most markets, businesses manage risk through contracts, a well drafted agreement, clear remedies for breach, courts that enforce them. In India, that last part is where the model breaks down. Enforcement is delayed, sometimes by years, sometimes by decades. So businesses operating in India need to think beyond the contract. And in a justice system plagued by delays, many times even beyond the law, that is what today's episode is about. Practical management of operational risks in India. Before we start, some quick points to keep in mind. These videos are not advertisements or solicitations. They are only for sharing information. Nothing shared here should be treated as legal advice. Please consult your own advisors before taking any decisions. And lastly, please read the disclaimers carefully. With that out of the way, let us first understand what operational risks actually look like in an Indian business. Operational risks in India fall into several categories. Regulatory risks, non-compliance with tax laws, environmental regulations, labor law requirements, or sector-specific licensing. These carry the highest stakes. Criminal liability for directors, operational disruption, reputational damage. Next, there is business partner disputes, disagreements with JV partners, suppliers, distributors, or key contractors. Then there are ownership disputes, particularly in family-owned businesses where succession is unclear or ownership is contested. You could also have labor disputes, termination grievances, union action, wrongful dismissal claims. And finally, reputational risks, media trials, social media storms, negative publicity that can move faster than any legal process. Our consistent view across all of these, except regulatory disputes, is the same. As a general principle, settle. Do not litigate. The cost of litigation in India, in money, time, and management attention, almost always exceeds the cost of a negotiated settlement. Courts are slow, outcomes are uncertain. The energy spent fighting is energy not spent building the business. Resolve commercially and move forward. So, what should businesses actually do to manage these risks before they arise? We have listed out some recommendations for foreign investors. These cover the risks most likely to derail a foreign business in India. First, keep regulatory compliance clean. Regulatory disputes are the one category you cannot settle your way out of, at least not in most cases having a material impact. Tax defaults, competition law violations, environmental breaches. These attract significant liability and cannot be quietly resolved. The solution is prevention. Keep effective advisors on retainer, statutory compliance calendars, regular internal reviews. Avoid aggressive tax positions. As we have said before, the saving is never worth the scrutiny it invites. Keep regulatory structures simple. When in doubt, seek a clarification. Use structures that regulators have approved before. Do not pioneer risky structures unless you really need to. Second, avoid concentration risk, one of the most common and most avoidable operational risks in Indian businesses. A single customer representing 60% of revenue, a single supplier for a critical input, a single regulatory approval underpinning the entire model. When that relationship breaks down, and in India they sometimes do, the business has no buffer. Diversified revenue, build alternative supply chains, ensure no single dependency can bring operations to a halt. Third, handle employee exits with care. Labor disputes in India carry risks that foreign businesses consistently underestimate. Wrongful termination claims, labor court proceedings, informal complaints to regulators, or grievances published on social media. Senior employee exits should specifically be managed carefully. Where possible, negotiate a clean exit. Pay a settlement. Get a proper release. The cost of a clean exit is almost always lower than the cost of a dispute. And be extremely careful about what is put in writing during an exit process. Emails, messages, memos, all can surface in disputes and worse on social media platforms. Fourth, stay away from political and social controversy. India has a vibrant and fast-moving public discourse. Political sensitivities shift quickly. Social media amplifies everything. A foreign brand that wades into politically sensitive territory, an ill-judged advertisement, a tone-deaf marketing campaign, a social media post by a senior executive can face a boycott within hours. Stay with the mood of the masses, neutral, inclusive, professionally managed. Have professional PR teams in place before a crisis occurs, not scrambling to find one after it erupts. Fifth, in crisis, PR and legal must work together. When a crisis hits, whether regulatory, reputational, or operational, the instinct is often to communicate publicly and defend the position. In India, this instinct must be managed. Statements made in public, press releases, social media posts, interview comments can be used against you in court. PR teams and legal teams must work together before anything is said publicly. Every public statement should be reviewed through a legal lens first. Social media messaging by senior management during a live dispute is particularly dangerous. Silence is sometimes the safest public position. Or stick to the standard statement. We are working with government authorities to address any concerns. We trust the legal system in India to do proper justice. Whether you do or not, stick to the script. It is non-controversial and simple. Resist the urge to mount immediate public defenses. Public responses in a crisis should be calibrated and cleared by professional PR teams and legal teams. Sixth, accept losses and move on. This is perhaps the most important operational principle of all. Not every dispute has a clean resolution. Not every bad outcome is worth fighting. India's litigation system will consume resources far beyond the value of many disputes. Sometimes the right decision is to write it off. Accept the loss, learn from it, redeploy your energy into what is working. The businesses that thrive in India over the long term are those with the resilience to absorb setbacks and keep moving. To sum up, contracts matter in India, but enforcement is slow. So the real risk management happens before disputes arise, not after. Clean compliance, diversified operations, sensitive people management, disciplined public communication, PR and legal aligned in crisis, and the willingness to move on. India rewards businesses that are operationally disciplined, not just legally protected. The legal framework is there, the courts are there, but the businesses that succeed long-term rarely need the latter. As the saying goes, an ounce of prevention is worth a pound of cure. In Indian operations, that ounce of prevention is worth considerably more. We hope this episode has given you a broad understanding for managing operational risk in India. If you found this video useful, please do share it. Thank you for watching and see you in the next episode.